response to that is that's also a classic doctrine that has been developed by the court to substitute for decisions in certain circumstances, which we say we meet. But if we were to talk about 5.2, for example, I would respectfully submit that that doesn't breach the separation of powers, because in the alternative, it would order a referral to the National Assembly to consider de novo, which the National Assembly would then do. And that also is not breaching separation of powers, because that kind of invalidation and reconsideration happens in constitutional litigation all the time.
Are you not, I'm sorry to interrupt
Sorry,
you.
Justice Sheetley.
Are you not asking us to say that the National Assembly should not have voted not to accept the panel report?
No, I don't think we see our case quite so broadly, because that would be an interesting debate about the separation of powers. The reason we impugn the National Assembly's decision here is because we say, insofar as the only reason that exists, it's this division of sufficient information and prima facie evidence, which I've addressed already. And because in our construction of the case, that's not a cogent reason, that's not a good reason, it results in an unlawful outcome, and that's why the court can step in. It's not a generic attack to say that whenever the National Assembly votes not to impeach, that's automatically unlawful. It's asking the court specifically to interrogate the reasons that were relied upon by the National Assembly in reaching that conclusion. And we say if that reason is unlawful, then this court can intervene. So with all due respect, I don't think we don't submit our case quite so broadly as the way in which it's being posited to me.
Thank you. CJ.
Thank you. Do you need to take a note?
I have no idea what it is, so I'm going to try and listen to you, Justice Majid, and then cast my eye downwards.
You can have a look at it first.
Thank you. I'm most indebted. Yes, I'm indebted, actually. What I would say, Justice Sheetley, going back to the debate that we had, apologies, Justice Majid, is that obviously we can accept that the substitution relief per se might create a separation of powers anxiety, but that if the alternative relief was granted, which is to specify or enumerate factors that have to be taken into consideration when that decision is reached by the National Assembly, that would be sufficient for us, because that in some way goes towards fettering and limiting a potentially unfettered discretion, which has the capacity of introducing political interference into the debate.
Thank you. I have a number of problems with the applicant's case. Some of the ground has been covered, but there are more, I regret to say. And you know, in Greek mythology, there's the Hydra with the multiple heads.
Yes.
And the myth is that once you chop off a head, it regrows two others.
Yes.
I hope it doesn't happen in this case, but let's start with, at the beginning, with delay.
I suppose two heads are better than none, Justice Majid.
Two,
or six in the case of my team.
Unless you're the one trying to chop them off like Hercules would.
Yes, no, absolutely.
But let's start at the beginning about the delay in this case.
Yes.
Now, as I understand your case, and please correct me if I'm wrong, your case is this. You say this debate about declaratory relief and review is just kicking up dust. You say it doesn't matter because in declaratory relief, you can claim more, or you could claim the same relief as in a review, and you're not bound to a decision. That's your case.
Yes.
So what you are saying is, I think if I read between the lines, that if it's a review, then delay comes glaringly to the fore. It would be a legality review, not so.
Yes, but it would hit more as to remedy, not as to the declaration. So it would hit more as to the 1721B inquiry, not the 1721A, because there's no doctrine of delay that will oust the court making a decision on the merits, but it may be that that is taken into consideration in the determination of the remedy. So yes, I accept that.
I must tell you, I don't follow that. I'm not going to try and understand it. I'm simply going to debate the matter on your case. Your case is declaratory relief.
Yes.
Now, you quoted Naptosa, and I looked in Aptosa for the silver bullet, and I couldn't find any. The silver bullet seems to be against you. Can we just go to the case, please?
Yes,
Do you have it in front of you, Aptosa?
it's coming.
Now, unfortunately, you would know that this is a 2001 decision
Yes.
of Judge Conradi in the Western Cape.
Yes,
So it doesn't have paragraphs.
yes,
It's pre-paragraph judgment writing time.
yes. And the version I have in front of me doesn't even have the internal numbering, so
Yeah.
I apologize for that.
But let's go to, let's go to the paragraph that talks about the flexibility, which is the one you rely on.
Flexibility.
Yeah, you know where it is more or less.
Yes, and what if I can ask one of my juniors to just search that judgment electronically, because then that will bring us closer to.
Yeah, they can do a word search.
Yes,
searching,
exactly.
Just look for flexible.
Yes, exactly.
But let me read what the problem is for you.
Yes,
Your argument is that based on Aptosa, declaratory relief can subsume review relief, so it doesn't matter. Well, it does. And that's also always how I understood the law, that declaratory relief entails a sense of exercise of discretion when it comes to remedy.
absolutely.
And their delay is one of the factors to be taken into
In the
account.
context of remedy, absolutely.
Because here the judge says, I consider that the substantial delay in bringing these proceedings, which was for declaratory, is another reason for exercising our discretion against the grant of a declaratory order. It says it is well-established law that undue delay may be taken into account in exercising a discretion as whether to grant an interdict or a mandamus, or to grant relief in review proceedings. And then he makes the point that you say it's a flexible remedy. But the point I'm making simply is this: can you and I agree that delay features even for your declaratory relief that you seek? Are you prepared to concede that?
For remedy, yes.
Yes.
Yes, and that has not been, we've not suggested otherwise. What we have contended, though, unlike in reviews, delay can speak to whether or not the review should be adjudicated in the first place, which is not a remedy question. We accept that the delay might be factored in the context of remedy, but it doesn't allow the court to, what we would say, sidestep the merits issue, which is the 1721A point.
Yeah. Well, I don't understand that answer, because if you say it's about remedy, doesn't it mean that you're not entitled to a remedy if you've delayed unreasonably? And let me immediately add why I'm saying this. It's not only delay. This seems to be a classical Van Wyk versus Unitas hospital case, because here you have a delay. And please, I'm putting the case as I see it,
Yes.
Mr. Premier. Please feel free to correct me where I go astray.
I'm indebted.
You have a 14-month delay
Yes.
on the papers,
Yes,
undisputed.
yes,
There is no explanation for the delay.
Yes.
And third, most importantly, there's an argument, which I'd like to hear you on, because you didn't address it at all in your uninterrupted time, that once the 6th Parliament has dissolved,
yes,
Section 49 and Rule 351 of the NA rule says, Parliament, 6th Parliament, your life is over, you're done, there's nothing left. So how can the 7th Parliament now be asked to consider work that died with the 6th Parliament? So mootness coupled with undue delay, and that is the problem that I have
Sure.
with the case, a la Unitas versus Van Wyk versus Unitas Hospital.
May I take both of those questions in turn, Justice Majid? Let me start with the issue of delay. I fully accept what you say to me, but what we know about the discretion to be exercised in terms of the remedy is delay is but one factor. So if the court is going to consider the unreasonable delay, that's fine, but then the court also has to counterbalance that delay versus the public interest in the matter, the ongoing effect of the court's judgment and the relief that it will grant. And then the court must bring an evaluative assessment as to whether or not the complaint of delay in and of itself is of such severity that it outweighs all of those other factors. And we would submit that it doesn't in this case for the reasons that we've addressed in the papers, including public interest, including the fact this is about the president who has special obligations to uphold the rule of law and so on. So on the subject of delay, I accept what you say to me, subject to what I've just added about the factor and the evaluation that you have to make. That's the delay point. Insofar as the second point is concerned, how I will try and answer the question is as follows. In the first instance, the court's declaration, if the court is with me, will invalidate everything that happened after the motion was tabled and restore, after the motion was tabled and after the panel gave its report, and restore that report. The status quo ex ante would be restored. That's the first point that I would make. So what the question then becomes, I suppose, is it competent for the 7th Parliament to adjudicate this report? Is it competent for the 7th Parliament to adjudicate this report which started in the 6th Parliament? And we would say, yes, it is, because when you restore the status quo ex ante, it's the National Assembly, not time-bound National Assembly in terms of the rule, but in terms of Rule 129, but the Assembly itself, which is then must then take the next step. So even though there's the issue of lapsing business, and we know that lapsing business is not absolute because there are instances where business is rolled over from one parliament to the next parliament. So it's not an absolute rule.
Well, that would be the revival of a bill, for example.
For example, yes.
But could you place it on the same footing as this matter? That's my, I looked at the revival
No.
of a bill. I
No.
understand that. But can you do this with a panel appointed under the previous parliament that has done its work?
Yes, agreed. It's done its
And
work.
gone to parliament?
Yes.
Parliament has decided. Now we've got a new parliament, a new mandate
but-
from the electorate.
But Justice Majid, this is not something uncontroversial. It's something that happens all the time. For example, like we know when a court invalidates a tender, for example, and when it invalidates the tender and sends the tender decision back to the decision maker, oftentimes there's a change of personnel. It might be a new director general, or it might be a new minister. The obligation does not attach to the individual occupant of the office. It attaches to the obligation to discharge the accountability function here to the Assembly itself. So we would say that in terms of what we are asking the court to do is nothing novel, and in fact only serves to emphasize the Assembly's obligation to discharge its accountability function. I know in the heads we refer to it as the ex-tunc versus ex-nunc debate. That's the way in which we see it, is the effect of the court's order would be ex-tunc in nature. And so the Assembly, however constituted and whenever constituted, would have to afresh then consider itself vis-a-vis the report. I understand the arguments that Justice Majid has posited against me. Those are as far as I can take it on that particular point.
I must just correct you. I'm not arguing the case. I'm
No,
just
yes.
trying to figure it out.
Positing the arguments, I should say.
Well, I want to tell you that we must compare apples with apples. It's one thing to talk of a tender which has been set aside and goes to another differently constituted
Yes.
adjudication committee. But here we're talking about the highest office in the land
Correct.
facing impeachment. And impeachment is not just, the end of a career. It means that you lose all your benefits.
Correct.
And it's a very serious matter. And that is why in this court, EFF2 said there need to be procedures in place.
Correct.
And they need to be complied with properly. And the National Assembly has the last say. That's the most important.
Correct.
Yeah. So I just want to get that out of the way. Now, I want to move on just to something else. And just to interpose and in brackets say that, I've listened to the debate between you and my brother Matlanga and my sister Tiki. And I read Makwakwa. Makwakwa are the people who fled from Lesotho after the coup d'etat. And then there was an
Yes.
application for extradition.
Yes.
The magistrate granted the extradition.
Yes.
And one of the things he had to consider was the prima facie grounds on which
Yes.
to grant the extradition.
Yes.
And in that context, Judge Musi, with whom Judge van der Merwe concurred, said, well, prima facie evidence means there's sufficient evidence for the warrant, for the extradition to be done back to Lesotho for them to be charged. Now, I mean, no disrespect to those judges, but in the context of that case, it's an understandable thing to say, well, prima facie evidence means sufficient evidence. Here, it's different. There are phases. The first phase we know is the member of the ATM comes to Parliament, says, here's a motion, and I contend there's prima facie evidence of these serious gross violations. Speaker looks at it, Speaker said, I agree with you, there's prima facie evidence. But now when it goes to the impeachment panel, this is a full-blown inquiry. It's headed by a former Chief Justice nogal, prominent senior counsel, well-respected retired judge.
Must be held responsible. Every president must be accountable. We did the same thing with Jacob Zuma. When he spent money on ganja.
It's almost like the police.
Yes.
The complainant comes to the police station. The leader of the ATM comes to Parliament, lays a complaint. Police look at this and says, well, there's prima facie evidence, there's enough here to arrest. But when the prosecutor must decide whether to prosecute, it is prima facie, but it is a different threshold. So isn't there two different thresholds? And that is why the legislature in its rules calculatedly use these two different terms, prima facie and sufficient evidence. I can't understand how it means the same thing.
So may I just pick up on the example that Justice Majid uses? That's exactly correct. And that's why we say that the way in which Parliament voted down the report ultimately is premature and constitutes a preemptive strike, because it didn't consider the correct question in front of the panel, which was about the existence of this prima facie evidence. So we agree on a proper interplay between what the Speaker does, what the panel does, what the committee does, and what the National Assembly ultimately does. The analogy of a police complaint prosecutor is exactly right. That's what it's concerned with. Is there a case to answer? So insofar as the analogy is concerned, I adopt it because with all due respect, we submit it makes our case. On the
Jacob Zuma, this organization is the one that fought Jacob Zuma. This organization is the one that is going to fight Zuma, and it will win. Even if we don't win in the immediate, we've got age on our side. He doesn't have age. Even if he dies tomorrow, we'll defeat him in the grave. We will follow him to everywhere he goes. Why? Fighters, there is only one political party that has made EFF its political program, and that is MKP. Yes. When they wake up in the morning, how many people do we steal from the EFF? Yes. How do we destroy the EFF? And then come and say, we want black unity. It will not come at the expense of the EFF. We must defend the EFF. We don't want to see MKP anywhere. We will meet in Parliament, even in funerals. We don't want them. They're everywhere. They're really gazebo. MKP's agenda is to destroy the EFF. Why? They are pursuing a white agenda because the EFF is the only organization that is opposed to white supremacy. Anyone who destroys the EFF protects the interests of white people, and we must never allow that. So fighters, when we are here today, we are very clear. We are fighting ANC corruption. We are fighting Ramaphosa corruption. That is what the founding manifesto of the EFF demand of us. When the EFF was formed, the clear mandate was, you must fight corruption. So everywhere where corruption shows its ugly head, we must confront it, we must nip it on the bud, we must defeat it. White people today don't speak about Phalaphala. This media did not make Phalaphala case a headline on Sunday papers because A corruption that is done by their favorite is not corruption. It's corruption when it is done by others. The media of South Africa must be transparent, must report corruption even when it is done by their favorites. There is no way a person can violate his oath of office and still stay in that office unchallenged. We are challenging Ramaphosa. We said Phalaphala will never die, and we are the ones who are going to keep it alive until the people of South Africa receive justice as to what was the president doing with the dollars under the sofas when the people of Deep Slot don't have food to eat. A person is sleeping on top of dollars. We must stop that corruption, because if we don't stop the president, it starts to be rotten from the head. Once the head is rotten, the whole of South Africa will be rotten. Today, you say police take bribe. Well, police are at the lowest level. It gets rotten from the head. We must fix the head. The police will come to order. The teachers will come to order. The nurses will come to order, because they know there is order on the head of the state. So fighters, please, let's be disciplined. The Secretary General is here, the DSG is here, the chairperson of the province is here, other leaders of our province are in the legislature, because there is a budget today. We are a big organization. When others are here marching, others are representing us in the legislature because we have multiplied. You can't say because there is a march, everything of the EFF must stop. EFF works in different levels. Please listen to the DOR, listen to your leaders, be under a proper control. Why? These people with cameras here, they are looking for something negative. When there is something positive about the EFF, they don't report. But one mistake, they report. Look at this weekend, Saturday, Sunday, we went to successful PGAs. There are not anywhere those PGAs on the papers. But if there was one PGA of Gauteng or Free State or KZN that got disrupted, we were going to be the headlines today. But because we run a smooth organization, they don't report about it. Whether they report about it or not, we will report about it on Twitter, on Facebook, on WhatsApp groups, because they are no longer a dominant factor. As long as they continue to report the way they are reporting, they are going to be irrelevant very soon. We will report our own news. We have our own podcast. We've got our own communication in the EFF. SAPC or no SAPC, we will report our own stories. So please, let's be disciplined. Let's go there and say to that court, if majority votes in favor of a wrong thing, it doesn't make it right. It remains wrong even when the majority have voted for it. In South Africa, every decision of the executive and the legislature must meet the rational test. That decision will not meet the rational test. The ANC abused its majority in parliament to defend their corrupt president. We will fight in parliament. We will fight on the picket lines, fighting for the constitution of the Republic of South Africa. Fighters, I'm very happy with how the EFF is performing in this province of Gauteng. I'm so impressed with the comrades of Tshwane. They took government today. In 3 days, they made Tshwane clean. When you clean after our people, you show love and respect to our people. When you give our people health and quality health, you show love to our people. our fighters everywhere here in Gauteng, especially public representatives, they are working very hard to show people how the EFF government will govern once elected in 2026. You must not be lazy. Continue to work hard. Continue to work for black people. Continue to love black people. They will show you love very soon. The election outcome does not mean your death. It means you did not work hard. You have to work harder so that you convince as many people as possible. Comrade, stay on a principle. Do not shake. Once usable, even when people don't agree with you and you are consistent, one day they like, but let's try this idea because this person has been consistent about these issues. Even if you are alone in your word, stand for the truth, stand for the principle, stand for the EFF. The people follow the people who are consistent. Nelson Mandela was called the rascal. Nelson Mandela was called ill-disciplined. Yet Mandela went to prison for 27 years. He never said, I'm going to leave the struggle so I can enjoy freedom with my children. You don't have 27 years. You are already tired. Mandela was not tired in prison. You are not in prison. You have 11 years. You are already tired. You cannot be tired. When you get tired, remember the story of Nelson Mandela. Remember the story of O.R. Tambo. For how many years was in exile? You are not in exile. You are actually favored by history to fight from your own home in South Africa. So what discourages you? Stand for what you believe in, and the future will open doors for you. EFF, you are on the right track. They are fighting you because you are on the right track. The dogs don't bark. They don't bark at the station car. How come I didn't tell you that's why I'm charging you EFF. EFF yatama. We are not stuck. We are not stationed. How koloi ikayema. Dimchadi humul. Gerutela. So now Gerutela dimcha. We are marching forward. That's where we are going, and that's what we are going to teach a lot of South Africans. Fighters, you must not be discouraged because but black people everywhere where they are bavotela ANC bavotela mara emakhuwa batelela bavulela ka EFF bathi ba re motšhini wa ulela batho ba bantsho ke EFF hauna any other party. Le bana ba di journalist aba tšhošetša di editor ba EFF e tlo fitla kwetsa. That's the power you have. Your power is not only on the field, it's on how you influence society. You are an influential force in the South African society. That's why you must continue to march forward. Babanyane ba 6 years, 8 years. Bande bare hana ke hola ko vote la EFF. Hey mama vote la EFF. Ane re vote. Why le bola EFF ye? Bana ba ka re ba hola ba swantse ba vote. EFF la ba re ba tlo vote la Isalon. This organization belongs to your children, belongs to your grandchildren. You are just laying a foundation for your own children. Hang in there. Do not be discouraged by people who speak negative. And then leave way. Let's catch up. You must fight. Also, nonsense. By EFF on the Facebook, on Twitter, on the streets, on the shopping. You must defend the EFF. you must defend the EFF in private and in public. Be proud of your organization, be proud of your leaders, be proud of yourself, because you are exemplary in your communities. You are going to be a successful story of black people. Once you become discouraged, you are destroying the hopes of many black people who looked at the EFF as that future, as that hope for them. One of the business people was saying to me yesterday that these people who left the EFF, they have set a generation 2 steps backward, because they understood this thing of ours to be a generational mission. This one of ours is not for now, it's for generations to come. When you kill it, you are killing generations to come. So please be aware that it's not only you, it is the people who say our generation is going to achieve land, our generation is going to achieve banks, our generation is going to achieve mines, and then you leave that mission, you demoralize a lot of people. They may not say it on your face. In their private spaces, they appreciate the role you are playing in your communities. Continue to fight, fighters. We are fighting today. We don't beg for friendship. We don't beg for relationship. Corruption is corruption, and we are exposing it today. Manda! 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 Siyabonga kakhulu Mongameli, sizwile ukuthi sonke siya constitutional court. So all those fighters at the back there, nalabo basafika, they must join us. We're going to follow the route. The commander-in-chief uzohamba nathi on the ground as always until sifike a constitutional court. Let us remain disciplined. Let us remain focused. Members of the media, thank you very much. You can move to the front. Ngoba lo mhlaba wethu manje siyawukhandala. Abantu!
Principle. EFF2 enumerated the principle, and this case now asks the court to test the mechanism chosen against those principles to determine if they're sufficient.
Please, can you repeat for me? Why do you say they're not sufficient?
Those are three overarching reasons. One is that the ability of the National Assembly to exercise a wide discretion at the point of the panel producing the report opens the door to political abuse. And so that existence of that wide discretion, where it's either the National Assembly has a role to play, or if it does have a role to play and it's not subject to factors, perpetuates the concern that was espoused in EF2. That's point number one.
Before you continue,
Sorry, Joseph.
Why is the wide discretion problematic?
Sorry, Justice Turan, I'm just making a note. The wide discretion is problematic exactly on the facts, as we would say, arise in this case. Because remember, even though when Minister Lamola was giving his address in Parliament, it was seen to be linked to a narrow evidential issue, what the affidavits reveal is that there were all sorts of political considerations and decision-making that was happening in parallel. And so in the absence of the National Assembly not playing a role when the panel produces its report, or in the absence of factors to be considered for the purpose of that decision, to fetter its discretion, that's where the potential for abuse arises. And that's where we say the structure of the rule needs to be tested for its sufficiency.
And that's where the potential for breach of separation of powers comes into play, as my sister Justice Chikwi was debating with you. Exactly there.
Yes, and I repeat the answer then given to Justice Chikwi in that regard, that at the broadest level, the separation of powers is not as much of a concern for us in the way in which we've constructed the case, and that the two alternatives that have been sought in this court are recognized alternatives that are used as remedies in this court in public law disputes all the time. So we would suggest that the separation of powers concern is not as acute as that.
Yes. The question of delay has been dealt with by Justice Majid, and I won't delve into it, but it does concern me that there is no explanation for the delay.
Yes.
What is the first applicant saying as to how it regards this court when it comes here 14 months late that does not give this court an explanation for the delay? I think it's just too glib to say, well, there are other factors that the court can consider in the interests of justice. Why is there no explanation for the delay?
Maybe it emanates from incorrect legal advice that the delay doesn't have to be addressed because of the declaratory order as chosen. But to the extent that there's a criticism that delay is inadequately addressed in the affidavits, that criticism is perhaps well-founded. I don't think Justice Turon is inviting me to now give that explanation.
I'm definitely not.
Exactly.
I'm voicing the concern
exactly
that the court has about that.
And I hear the
And
concern.
I'm giving you the opportunity to answer how we can address that concern, not giving you the opportunity to
Yes.
give any
No.
evidence, Mr. Premier.
No, that's entirely right, and it would be inappropriate if the invitation was extended. The point is that the court has, in other circumstances, and I will address this more fully in reply, and I'll make a note to do so, has dealt with other cases where there have been substantial delays, and it has.
But now it seems that the court is creating problems for itself where it attempts to assist litigants. And perhaps the court should not be doing that. So litigants should know when there is a delay, there's a duty upon
Yes.
them to provide an explanation to the court.
Yes. Now, I hear the criticism and I hear the concern, and I quite frankly agree. But stare decisis is as stare decisis does. And if the court has exercised its discretion in the interest of justice in other matters where delays may have been insufficiently explained, that's the
And
sum total of the explanation, I guess.
The applicant filed a consolidated replying affidavit in
Yes.
this matter. And in that affidavit, it raised certain new issues, one of which I had covered with you.
Yes.
There was a further opportunity to deal with the delay. And this is after the respondents in their opposing papers had already criticized the applicant for not providing a reason for the delay. So despite that, despite being made aware of the fact that there was no explanation, the applicant still did not at that stage consider it necessary to tender an explanation.
And I must accept the criticism. One's also caught between a rock and a hard place in that instance, because then if one strays into an explanation on a so-called new issue not addressed in the founding affidavit, the immediate response is you're then making out a case and reply. So in an imperfect circumstance where delay is raised as a respondent as an issue that is relevant for the matter at hand, it is somewhat difficult for an applicant who finds themselves in that situation to then deal fully with an explanation on delay, particularly where, and again, this is subject to correction by this court, obviously, it chooses a modality of relief that delay does not play as much a part as it would if it were a review, for example. But I hear what Justice Turon says, and the issue is as it is on the papers.
My last concern, which has been touched upon, is that of doctrine of breaching the doctrine of separation of powers. Now, once again, is there any precedent that you can point me to from this court where substitution has been ordered in a case like this? Where substitution has been ordered by this court, where there's a danger of breaching separation of powers?
No. Other than, on similar facts to this case, I would say no. Obviously, the separation of powers issue and substitution.
On any facts, doesn't have to be similar to this case, but where there's a danger of breaching separation of powers, has this court ever ordered substitution?
And are we limiting the engagement only to issues of exclusive jurisdiction, or are we saying generally? Because there is a case, and TRENCON is the leading authority on the substitution point, where the separation of powers was foreshadowed by the court. And the court's answer in TRENCON is that separation of powers is actually not really a concern, because the court ultimately is the one that enforces the Constitution. And if the repository of the public power exercises that power incorrectly or achieves an unlawful outcome, then the court, if it is well placed enough to make that same decision, can, despite the separation of powers concerns, because all of the exercise of public power stems from the Constitution, of which the court is the upper guardian. So
I'm only going to remind you of the opening sentence of the minority judgment.
the minority judgment, yes, Justice Turan.
Are you relying on the minority judgment?
No, no,
Yes. I'm going to remind you only of the opening sentence of the minority judgment in I think it was, yeah. It was the secret ballot.
My
Yes,
vote
UDM,
counts.
the UDM matter.
Oh, UDM, yes.
Yes, where the minority judgment started with, this is a classical example of judicial overreach. So separation of powers is always a concern, Mr. Premier.
Yes.
Yes, but
Well,
I leave it at that.
Justice
And we shouldn't downplay it.
No, Justice Turan, may I say, as a conservative constitutional lawyer, I completely agree with you and endorse your sentiment. But the reality is that the court's precedents are what they are. And unless any respondent in this matter or this court itself is willing to impugn its prior decision, stare decisis applies. And Justice Brunt, if I'm not mistaken, when he was an acting judge of this court in Camps Bay, made that abundantly clear at para 28. Precedent not only applies vertically, it applies in respect of the court and its prior decisions. So in as much as the separation of powers concerns are what they are, the majorities in these judgments have broken the other way, and therefore they're justiciable principles which a litigant can rely on. But I share your concern.
I'm not going to engage in a debate, Mr. Premier, about whether this court has in cases breached separation of powers or has gone too far. I'm not going to engage that debate. I've raised the concerns and I leave the matter there. Thank you, Mr. Premier. Thank you.
Thank you, Justice Turan. May I just, Justice Turan, before I face questions from someone else, there was the question that was asked specifically about examples in this case. And I see lots of a flurry of activity from my teammates suggesting that the answer is EFF 2 at para 46. I think I have. No, I apologize. It's not EFF2. The issue of substitution was TRENCON at para 46. That's the reference I wanted to give. My apologies.
Yes, thank you.
Mr. Premier,
Justice Phalaphala.
you relied on DA versus SABC. I just want to get some clarity whether you seek to invoke it with regard to what a future scenario might look like, rather than what the present scenario is. Let me be specific. In DA versus SABC, the court concluded that the report of the public protector was binding,
Yes.
unless it was reviewed and set aside.
Yes.
That's not the case here when this
Correct.
report served before Parliament, correct?
Correct.
So whether we ever reach that stage is debatable, because the independent panel is quite different from a Chapter 9 institution. Chapter 9 institution gathers evidence, tests the evidence, subjects it to cross-examination, etc.
Yes.
And therefore, for a court to conclude that that report is binding is underpinned by a number of jurisdictional facts which doesn't exist
Absolutely.
yet.
Absolutely.
So having set that aside, would you then accept that if the report was not binding on Parliament, Parliament was at liberty to consider the report and to consider it critically,
Yes, but
but not to have the wide discretion that you say it did?
we're at Eden.
Fine. Now, even if it had to use a narrower discretion, it's calling into question of whether the panel misconceived its role in setting the standard at that of a prima facie case. And we've had the long debate with my other colleagues. Would not appear to be unreasonable. Certainly it was a valid point to raise and would fall within its narrow discretion.
Justice Colopin, subject to if I've misunderstood your question, the issue for us is not, the inclusion of factors is not applicable as against the panel. The inclusion of the factors is as against the narrowing of that wide discretion that otherwise vests in the National Assembly. And the reason that we say that those factors, which is the alternative to the automatic referral issue we've debated, need to be present is because, like the court identified in EFF2, and it decided as similarly in Oriane Ambrosini and Mazibuko before that, is that these rules, in as much as they are presented as neutral.
Sorry to interrupt. you
Sorry,
there.
Justice Colopin.
You're postulating what the ideal situation should be. I'm really wanting to get to what was before the National Assembly and whether they were, absent any amendment to the rules, entitled to critique the report, certainly on the basis that the panel got it wrong on the law with regard to the test.
Yes. But
If that is so, then surely that can't survive a rationality challenge. And secondly, surely in that regard, Parliament would have discharged its obligation to hold the President accountable. Because to hold the President accountable doesn't automatically mean that you have to establish an impeachment committee.
you know, I fully accept
It would
that
have been
last.
entitled to say, well, we've
Yes.
got this report that requires a level of sufficiency.
Yes.
The panel misconstrued its role by lowering that standard to one of a prima facie
Yes.
standard, and on that basis, we're entitled not to adopt this report.
But that only survives constitutional scrutiny if the reason relied upon by the National Assembly to vote down the report on that basis is itself a lawful reason. And if it's a mistake as to fact or a mistake as to law in terms of what the different thresholds means from Hurton Carter and ATM versus the Speaker, which are recent SCA judgments, if that is material to the outcome because of what the court previously said in Allpay, then that vitiates the decision with unlawfulness. So I wouldn't be willing to say it survives a rationality challenge because that invites the question about whether or not the reason relied upon was an actual fact a good reason.
Well, it may well be
Yes.
on the basis.
Yes. But I hope I've answered that rationality point, Justice.
Oh, you've responded, thank you. And just finally, there's a principle, and I can't remember the case, where the lawmaker uses the same term in legislation, then it must be given the same consistent meaning wherever it appears.
Yes.
And the corollary of that must be that when the lawmaker uses different language, then it must be intended to give it a different meaning. And I simply ask this question in the context that it was open to the rule makers to use prima facie consistently. If it intended that to apply in respect of a motion and intended it to apply in respect
Yes.
of a report. Is it incumbent upon us to go beyond that, to say, well, it must have meant prima facie, and therefore it doesn't really matter what the panel's interpretation of it was. We have to give effect to whether what does the rule mean, and did the panel understand the rule correctly?
Yes.
If it got it wrong, it got it wrong,
Yes.
irrespective of how eminent the panel may be.
Yes, and as eminent as they may be. No, so three very brief responses, if I may, Justice Colleton. In the first instance, we would say that that distinction is no distinction at all. You've heard me on that already. So in the panel applying its mind and equating those two things, there's nothing wrong with that because those are all within the same species of prima facie. That's the first point. The second point is that,
I just want to intervene by saying that
Yes.
if that was its case, then there would have been no need for it to place anything before the president, not so. Because prima facie is what is presented to it by those who complain.
yes,
By making the information available to the president and the supplementary information and giving the president an opportunity to respond, surely that took it to a different level than the original motion.
yes,
And therefore, sufficiency under those circumstances must automatically lend itself to a different and a higher standard.
yes, which we say the panel met here. Because of,
Whether it met it factually is another matter, but it characterized the
Yes.
standard. You could argue that if you look at the report in its entirety, it may have met a standard beyond sufficiency.
yes,
But that's not the question
Yes.
we must answer. The question we must answer is the panel decided that the standard it had to meet was one of a prima facie
yes.
case.
And you've heard me on why it's doing so is competent. So that was my first set of answers. My second set of answers is that the nomenclature difference need not necessarily arise in a different standard if applying the rules of interpretation results in a sensible outcome. Obviously, the debate is whether the sensible outcome is the higher standard or the lower one vis-a-vis the panel report and the motion. But we say that that's the consistency that is evident throughout the rule. And the last response is that the panel here doesn't do something akin to what the SEA did in the Moyo and Sonti matter, where in seeking to save, I think it was the Intimidation Act, if I'm not mistaken, or maybe it was the Incitement Act. I speak subject to correction. What the SEA did is it read in a whole number of qualifiers in order to rescue the provision overall in terms of its constitutionality. What the panel did, to the extent that it applied its mind and said that sufficient and prima facie is the same, is not in that territory at all. So to the extent that there has been a difference in the nomenclature and it's been interpreted in a particular way by the panel, then that's fine in our construction because it's not actually a reviewable error that they've committed. They've adopted a standard of evidence which is defensible in law. Thank you.
Mr. Premier? I'm here.
Sorry, Justice Matopa. May I just give one last reference to Justice Colleton, if you don't mind? And on the facts, Justice Colleton, the reference I would give you is in page 90, volume 1, paragraph 76, from line 22 onward. And the panel in its own words says the following: it is a momentous act justified only when sufficient evidence exists. Remember, sufficient evidence is what is used in the rule. Sufficient evidence exists to show the president has a case to answer for his conduct. The panel therefore functions as a filter to ensure that only a motion which establishes prima facie that the president has a case to answer is considered by the impeachment committee. So assuming, Justice Colleton, that there is the distinction between prima facie and sufficient evidence, what the panel is doing here is it says that that's that higher threshold that we're meeting all the time. We're just calling it prima facie evidence.
Well, I think this creates further difficulty for me because what it says is the panel therefore functions as a filter to ensure that only a motion which establishes prima facie the president has a case to is considered. But that's precisely what the speaker has done, Natsa. The speaker has satisfied herself
Yes.
that the motion satisfies the requirement of prima facie evidence, and therefore the speaker has no discretion. The speaker is obliged to appoint the panel.
Yes, but the speaker's assessment of that is measured as against the 129A provision, whereas the panel considering that sufficient evidence threshold is as against 129G. And so and again, I think it takes me back to the debate I was having with Justice Shikri earlier about the duplication, then what's the purpose of the panel? It's that the speaker doesn't play as intensive a role as the panel does. And so even though the speaker considers whether or not there's the prima facie evidence, that's only in terms of the tick box exercise for the competency of the motion, not the underlying charges. That's the role to be played by the panel. So when the panel talks about the motion, it's a motion that passes the speaker's hurdle, but on its terms as a charge sheet, if I can call it that, is competent to make the prima facie threshold.
Okay. I think we've
Yes,
probably been, yeah, thank you.
thank you, Justice Colopin. Justice Matoko.
Just to follow up on that last part,
Yes,
if you look at volume 2,
yes,
at page 143,
I'm with you.
there's been the report of the panel. This is what they say. Viewed as a whole, the information presented to the panel, it's not them, prima facie
Yeah,
establishes that there was a deliberate intention. So the word prima facie has been used throughout by the panel.
it has. But the earlier portion that I read to Justice Colopin is an earlier paragraph where they're explaining what they understand by that.
Now let's look at that.
Yes.
You and I as lawyers. If the panel uses the word prima facie and sufficient evidence interchangeably as if these were synonyms, that is wrong. Forget about what Makwakwa said. My brother Majid has taken you through
Yes.
what Makwakwa said.
Yes,
That is wrong. And if a wrong test has been applied, it invariably would lead to a wrong conclusion.
yes,
So isn't the case here that the report has to be impugned because it is based on a wrong test? The panel conflated the two tests
Yeah.
as if it's one and the same thing.
Yeah.
You and I know that it is not. We have to search through the report to find the word sufficient evidence to save it. This is a report by 3 eminent lawyers. Do you have an answer to that?
I'm not going to repeat my submissions that you've heard already on the issue of the threshold. But I think in the way you've constructed it to me, I accept what you say, Justice Matoko,
This
subject
court,
to that caveat.
just to remind you, this court in State versus Tuta, a judgment written by acting Judge Unterholter, in which my brother Colopin also wrote a minority judgment. There was a misunderstanding or a misapplication of the test. And as a result of that incorrect application of the test by the trial court, it came to this court, the conviction and sentence was set aside.
Yes,
And if that's the case, then Tuta is against you, number one. 2, you know the tests in criminal law, it's proof beyond reasonable doubt. If a court convicts on a balance of probabilities, the test has been incorrectly applied. The examples are myriad. So even in this case, the fundamental or the fundament of the report by the panel is just wrong. It must be called for what it is.
sorry, Justice Matoko.
Do
May I
you
respond?
agree or you don't?
I disagree on the basis of what I read out earlier, because the risk inherent in what Justice Matopo is positing to me is what I would respectfully say is a form of a substance error potentially. Because what the panel says is the panel in its mind, and based on that earlier paragraph that I read out, which if I can get it, it will be helpful. But based on the earlier paragraph that I read out, it's not that they were thinking about two separate things. Even though they might have used prima facie evidence subsequently in the report, what they continuously tell you insofar as how they understood the meaning of that is that's related directly to the evidence of justified only when sufficient evidence exists.
But look at the conclusion that I've drawn your attention to when I first started my
Yes.
question. It says viewed as a whole. In other words, in conclusion, that's what they're saying. They've nailed their colors to the mast.
But
That's what they're saying.
I-
Forget about how they took the journey or they undertook the journey.
Well, I think that puts me in a difficult bind because it asks me only to consider what they say in the conclusion, despite what they give earlier, which adds color to that conclusion, which is the paragraph that I just read out. I mean, if I have to ignore that, then the way in which Justice Matopo presents it to me is unanswerable. But I would say that that is at the risk of the form over substance issue because of what they say here at para 76.
Are you prepared?
75?
Are you
No, it's
prepared?
76.
Are you prepared to accept that at the initiation of the complaint, there has to be a prima facie evidence?
Are you talking about Justice Matopo when it goes to the speaker?
Just at the beginning, initiation.
I accept that.
And are you prepared to accept that when the panel conclusion has to be based on sufficient evidence or both, or it doesn't matter?
Well, based on what I read out, it doesn't matter because they've equated it to the same thing. Substantively, even though they're calling it prima facie evidence, that the test and the threshold which they themselves are seeking to answer is as set out in that paragraph, which is sufficient evidence exists for the president to answer a case.
Okay, let me wrap up and move on to something else different briefly. What I don't understand is why the applicant did not directly and frontally challenge the rules. One, the relief that has been sought, the resolution that was taken in December, and everything that goes with it. The ship has left, has sailed out. If the EFF had challenged the rules and asked for an amendment before the National Assembly, wouldn't that have been a prudent move to do? Short of lumping the whole thing with what it has done now,
No,
I'm
because
bringing into question the issue of delay, mootness,
I hear you.
prematurity.
No, I hear you. That would only be competent vis-a-vis the attack on the rule, but then it would still leave the substantive outcome of the National Assembly's decision and what is to be made with that. So the EFF is in the court because it says that's the exclusive jurisdiction issue. And because the decision that was made and which is being impugned is in terms of Rule 129, that invites it and this court then to consider the competency of the rule as it is now constitutionally challenged in front of this court. The EFF's case is not only about the rule. If it was only about the rule, then I think Justice Matopo's observation is correct. Maybe it should have gone in the High Court and started there and attacked the rule or whatever else.
Yeah, but how good is the EFF's case in respect of the other prayers? I mean, let's look at it practically. What is it seeking to do?
It's seeking to
I
get,
mean, if it goes to the rules, it's something else. It might have a case to sustain. But all the other reliefs, I don't know. Hasn't it misconceived its position? Just think about it. Move away from the issues and look at the practicalities. And take a step backwards and look at the issues. What is it that the EFF seeks to achieve? The EFF seeks an amendment to the rules. Its complaint is not what happened, because the boat has sailed. Its complaint is the rules as it is now gives us a problem. That's where the problem is. No other problem. All of these things are just lumped up to create an atmosphere. Just, do you agree with me or you don't?
I disagree, and I disagree for the following reason.
Mr. Premier, would you mind giving us the reasons after the tea adjournment?
Of course.
Come back at 11:30.
The first one is this. It's whether or not the reasons offered by the National Assembly when it voted down the independent panel's report withstands legal scrutiny. Now, what has happened in this matter is there have been two bundles of reasons that have been advanced before this court. The first bundle of reasons are those reasons that were given at the time by then Minister of Justice, Minister Lamola, in the House and is recorded in Hansard. That is, can be found at EFF Annexure 6, which runs on to 2 volumes, if I'm not mistaken, and I'll take the court there in due course. And effectively what Minister Lamola's reasons are is that the panel misconstrued the threshold it had to apply. And he and developed by our learned friends for the ANC in argument seek to draw this distinction between sufficient evidence, sufficient information, and prima facie evidence for the purposes of an impeachment motion. And what we will submit to you, and when the court considers this argument, is that insofar as that is a reason as to vote down the report, it's not a legally cognizable reason. And it's not a legally cognizable reason. I see the acting Deputy Chief Justice raises his eyebrows at me. It's not a legally cognizable reason, ADCJ, for this simple fact. And that is that there is binding authority which tells you that prima facie evidence exists on a spectrum, and that the objective to find prima facie evidence for the purpose of a motion is not to subject the initial sifting mechanism done by the panel to the same threshold as actual guilt. It's something lower than that. And to the extent that the panel engaged with sufficient information and prima facie evidence, the panel discharged its responsibility accordingly. And that's why that reason, insofar as that is the principal reason in front of you is concerned, that's no reason at all. There are some reasons which have been introduced, particularly by the president and the ANC in this matter, where they've talked about various things being, which I am loosely going to say, they characterize as the report being fundamentally flawed. They actually use that phrase in their pleadings and in their heads of argument at various points. And the argument, as we understand it, seems to be that never mind the sufficient information versus prima facie evidence issue, which I've already addressed in passing, is that this report was so fundamentally flawed that it had to be voted down because of how nonsensical or misconstrued or misapplied it was. And what we say is that it's trite that those reasons which find their way before this court, not in Mr. Lamola's words when given in the House, but under Mr. Figile Mbalula, the Secretary General of the ANC's answering affidavit filed in this court, that's an ex post facto justification, and that's too little too late. And in any event, even if those reasons were competently in front of the court, which they aren't, because the court will know that none of the respondents seek a collateral challenge of the report in any way whatsoever, that those reasons cannot be relied on the court to justify the National Assembly's reasons for voting in the way it did at the time that it did so. So that's the issue of whether or not the reasons are sufficient in the context of that debate, and that implicates all sorts of other underlying issues like rationality of the decision and so on, and I'll develop those in a short period of time. The second overarching consideration that we say is important for this court to bear in mind is this. he sought to review and set aside the report for the alleged flaws of the report. It was about the panel and the report. Here, we're about something entirely different. We take the report as a legal fact. The existence and the content of the report is a fact that cannot be properly disputed in front of this court, despite the fact that the president and the ANC repeatedly invite this court to do so. But that being said, once you accept that the report is what it is in the EFF's construction of the case, and it becomes rather instead about how the National Assembly responded to that report and whether or not its response is one that advanced its constitutional obligation of accountability or not, that's what makes it exclusive jurisdiction as opposed to direct access. So to the extent our learned friends want us to argue direct access and don't want us to be here on direct access, that's for them to make, not me, because quite frankly, direct access has very limited role to play in these proceedings. So that's exclusive jurisdiction, issue one. I can't remember what the next one was according to the Concourt's tweets yesterday about the 6 issues that the court is facing, but I don't take that as binding. So the second one I'm going to move on to is the issue of declaratory relief. Can I just say this about declaratory relief? Because how the debate has unfolded before the court is in this way. On the one hand, what we say on behalf of the EFF is this is a declaratory application. It's a classic 1721A, 1721B type of application, which this court will know from Rail Action Commuters Group, I beg your pardon, is a flexible remedy that has the ability to apply to a wide variety of situations, including ones where a review may be competent. But just because there might be some overlap between a declarator application and a review application doesn't mean that a litigant is forced necessarily to choose one or the other. And particularly in circumstances here where there's no subsidiarity issue, such as PAJA standing in our way, then we say that that distinction is even less cogent in the context of this debate because of the way in which the court has already understood declarator applications to apply. And may I just make this point about declarator applications? The court will know that we rely on the Naptosa judgment, which, if I'm not mistaken, is a full court judgment from the Western Cape High Court. And what the full court there says about this review declarator distinction is it says the following. It says that in matters like this one we would submit, where a record is not necessary, then a declarator can play the role of a review. But what we would submit is the opposite is not true. And that you cannot then magically manifest a review into a declarator. So why I'm saying all of this is because to the extent that our learned friends think that there's some magic in this distinction and that they can non-suit us because we chose a declarator as opposed to a review, we say with all due respect, that's neither here nor there. That distinction is a false one. And to the extent that they advance that, there's no cogent argument which suggests that this somehow falls outside the scope of what a declarator is interested in. The court will very well know from Cordian trading what the two-part test is for a declarator application. The first one is the decision regarding the contest of rights and future and contingent rights. We say we tick that box. And then the second leg is whether or not the court should grant the remedy in its discretion. We say we